Everybody. Good morning, and thanks for joining us with the eviction process. Um, I just want to have an idea if you can put in the chat. I always like to ask this in the beginning if anyone's ever had to kind of walk a person through an eviction. If you can just say yes or no, it'll just give us a general idea. And Larissa, if you can let me know, how's it looking? I see everyone's responding.
Looks like most of
Yeah,
it
I'm gonna have to
No.
Okay.
God damn it, I'm so busy. Like, okay.
You guys, if you can mute, we hear people talking. Mute yourselves,
All
please.
right.
Not muting, except you, of course.
Okay. All right, that gives me a general idea. So we're going to just talk about this, and if you have any questions, you can put them in the chat, raise your hand, and I'll try to answer your questions as best I can. Oops, I went a little bit too far. I always like to tell people that I am not a lawyer. I always say that. I can't give you any kind of legal advice or anything like that. I'm not a lawyer. So please, let me go back. First of all, we're gonna talk about what it's like, what's the difference between a notice to vacate and an eviction notice. A lot of times people get those two things confused. We're also going to talk about the timeline of the eviction process. The reason I feel that is so important for you to understand is because I'm sure if you've ever worked with people in housing like I have, you've gotten these frantic calls from a tenant who says, oh, the landlord says I have to be out by Saturday, and here it is Monday. Well, that's not quite true. That's not true at all. So we want to help people understand how it really works so they don't get frantic and make decisions that could impact them, because a lot of times things can be worked out. We're also going to talk a little bit about how to avoid evictions rather other than just following the lease. There's other things you can do. So again, I can't advise anybody. I have information, but the information I am giving you is information I've gathered through years of experience, talking to legal aid, going to court. I've gone to court with other people on evictions and things like that. But if you really want to know what the law is and what a person's rights are under the law in North Carolina, and I say that because it's different from state to state, but in North Carolina, please contact legal aid. The last slide in this presentation gives you resource information on legal aid and how to contact them and everything. So let's first talk about the difference between a notice to vacate and an eviction notice. In the state of North Carolina, if someone is about to be evicted, the property managers need to give the tenants a notice to vacate first. Okay, so they don't just go right to court. If rent is late, they don't go right to court and just file an eviction notice. They give them a chance to cure it or to resolve it or to move out without having an eviction on their record. So a notice to vacate, which is what they get first, it comes from the property manager. It's not a legal term, so to speak, but it's a notice saying you have 30 days, you have 10 days or whatever to vacate the property, and it will tell them why. It won't just say you have to leave. It'll tell them why. A lot of times the notices to vacate, they will not come until several violations have been received by the tenant from the property manager, whether it's a private landlord or a unit, a property that's subsidized by the federal government or whatever. They'll usually get violations. They don't just give you, the first thing they give you is a notice to vacate. Properties, it's a lot of work for them to evict someone. So they work with the tenant in most cases, so they don't have to evict them. Plus, an empty unit means no money. So they're going to work with you to try to keep you there. So the notice to vacate comes from the property manager, but an eviction, when you say the word eviction, you should not be saying that unless you have a court document. It's filed in civil court in North Carolina. It's a $96 fee. So it's filed in court, and that's just for that paperwork. I think it's another $30 to actually file it. To fill out the paperwork and all that, it's $96, and then it's another $30. So try to remember not to use the word eviction unless the tenant has actually received a court ordered document. The tenant in a notice to vacate, the tenant gets 30 days or more or less to move, depending. We're going to talk about that, but it's typically 30 days. For an eviction, there's a hearing that is scheduled within 14 days. So once a person files for an eviction, if it's on the 1st, the court hearing has to be scheduled within 14 days of that. Okay, so they can't just drag it on and on and on without a person knowing what they can do. For a notice to vacate, again, the tenant can appeal within 10 to 14 days. I say 10 to 14 days because depending on the property, some properties will give a person 10 days to appeal the notice to vacate. Other properties will give someone 14 days. Those are the two numbers I've seen. I've not seen like 11 or 12. I'll either see 10 days or 14 days, but they can appeal it. With an eviction, if you go to court and if you lose that eviction, that court hearing, and the judge grants the property owner possession of the property, that tenant still has 10 days to appeal that. And I will tell you, it's not often that they'll even appeal, but I've seen people appeal, and I've seen 2 people actually win and get to stay in their unit. So it can happen. It's extremely rare. It's extremely rare, but it still means that for 10 days, that landlord or property manager cannot pursue the eviction. Even if they won, they have to wait at least 10 days. Once those 10 days are up, then they can take it to the next level. For a notice to vacate, it cannot be enforced without court intervention. So this is what I'm talking about. When you hear a tenant give you, frantically call you saying, oh, I've got to be out but in 10 days, I've got to be out in 5 days. No, they don't. The notice to vacate will tell them they need to be out, and they really need to work. That don't ignore the notice to vacate. Talk to the landlord, see what can be worked out. However, if for whatever reason, and there are a lot of justifiable reasons why they cannot be out in 10 days, then the property manager will have to go to court. But a notice to vacate in and of itself does not mean a person has to leave immediately. It does not. The only thing that can make them leave is a court eviction. And again, that's a process that you're going to see happening as we go through these slides. Any questions right now? Okay. The notice to vacate. There's no fees involved. The property manager just writes a letter to the tenant. The court eviction, I already told you, it costs $96 plus another $30 for to file it. Then if it's a property with lots of units and all that stuff, the tenant can also be responsible for attorney fees. A lot of these properties have attorneys that handle all of this. With private landlords, they go to court themselves, but the bigger properties, they have attorneys, and the cost of those attorney fees can be attached to the tenant so that it comes out of their pocket. With a notice to vacate, late rent and fees will apply. So if you get a notice, if someone gets a notice to vacate, say they get it today, okay? So what is today? Today's the 14th, okay? Say I get a notice to vacate and I have to be out by the 15th. I can't say, well, they want me to leave, so on May 1st, I don't have to pay my rent. Yeah, you do. If I'm living there, I still have to pay the rent. And if I left on the 15th, then they would owe me rent. Now, here's the weird thing about that though. With an eviction, they can demand on that court eviction, they can demand late rent, fees, damages, if they know of any damages, and still require the tenant to move out. That's called possession only. Yeah, I want you out as a landlord, but you still owe me money and I want you to pay that. So I can sue you in civil court for both of those things. However, here's the caveat a lot of people don't understand. If that landlord accepts any money from the tenant, this eviction process is null and void. Oh, well, that erases everything because you accepted money from me. While this eviction, while we're waiting on the date or to go to court. If the landlord takes partial rent, next month's rent or whatever, it voids the eviction. So if something happens and they say, well, I have this eviction notice and you still have to go, the landlord has to start all over, has to pay another $96, has to file all over again. He can't use that one eviction that they started with. Any questions about that part? Okay, so the property
I
manager
have a
can
question.
hire. Yes.
I'm sorry, I raised my hand. You probably can't
No,
see
no,
it.
that's okay.
This is Monica. How you doing today, Ms.
Hey,
Natalie?
Monica, I'm good.
I have a question. So if a tenant if the tenant wants to go pay the rent and the landlord doesn't accept it and there's an eviction already filed, can the tenant still go pay the court as a bond to hold that money for the rent if the landlord didn't accept it?
That's an excellent question, and I do not know the answer to that, but I can find out for you.
Okay.
I do know that if the tenant tries to pay the rent and the landlord does not accept it, they can put it in some kind of trust. I don't know if it goes to the court. I don't know how they do that. I think in different counties, it's, they do it differently. I don't know how it is in Wake County. However, if a person says, well, I tried to pay the rent, I would strongly urge them to hang on to that money because they may win in court.
Correct.
If they want to fight it. And I'm glad you brought that up, Monica, because, I hear people say all the time, well, I tried to pay and he wouldn't accept it. Landlords don't have to accept your money. Sometimes they just want you out, and they have every right to do that, especially, like I said, if you've received lots of violations. So, Monica, I will find out about that and let you know because, again, I don't know if they can pay it to the court, but I do
know in Onslow County they can, and in Guilford County, but I wasn't sure about Wake County.
Yeah, in Wake County, it's so big, I don't even know if they have anything set up like that, but I'm certainly going to find out because that's a good question. Thank you.
Thank you.
The property manager on a notice to vacate, they can hire a collection agency to collect the money owed. So say you leave, you lost the eviction or whatever, they can hire a collection agency. So you really don't want people coming after you for money. So I always encourage people to try to work it out. Even if it's a payment plan, try to have something in writing that you've been cooperative and try to work it out. Now for an eviction, if the landlord wins, he or she can place liens against wages, your property, your car, your bank. They can do that. So just be aware of that. I've never seen them really do it because we deal with people who don't have a lot. So I've never seen it, but it can happen. So what are the elements of a notice to vacate? You're going to have the date on there. The tenant's name and address will be on there. And it's usually got the company letterhead or the property manager information. Now, sometimes when I've worked with, I used to work in okay, thank you. I used to work in ILI, or I used to do rapid rehousing, and we would tell people, in order to help you, we need a notice to vacate or a late notice. We would get, some of the private landlords, we would get these little hand scribbled notes that I couldn't even read that would say, your rent is late and you owe me $790. That's it. That's not good enough. It has to have these elements on it. You want to state that the tenant has 30 days to vacate. Okay, so you want to make sure you put that on there. State why the tenant is being asked to leave and cite specific lease violations and dates, if any. Sometimes they do that, sometimes they don't, but that's what it should have on it. And explain on how to appeal. So like I said, or how to appeal notice to vacate. Usually it's 10 days, but a landlord or property manager will say on there if you would like to appeal this decision or something like that, and then it'll give you the information on how to do that. So your rent is late, what do you do? In North Carolina, late notices cannot be issued until after the 5th of the month. So sometimes people get late notices on the 4th, they get them on the 5th. They cannot get them until after the 5th. And that's if the rent is due on the 1st. So basically, after the first 5 days, they cannot receive a late notice within that 5-day grace period. And unless it's a monetary violation, criminal activity or criminal activity is involved, a 30-day notice to vacate must precede a court eviction. I told you all about that. They can't just go straight to court, okay? So they need to have that 30-day notice to vacate. Again, although you may offer to pay the rent arrears, landlord doesn't have to take it. He just might want you out of there. He might just want his property. So a little bit about the notices to vacate. If it's a year-to-year lease, that notice to vacate must give the tenant at least a 30-day notice. And this is on a 12-month lease. Now we know that a lot of times after 12 months, the lease automatically goes month to month, okay? So if it's a month-to-month lease, the landlord only has to give a person a 7-day notice. Now, I will tell you that a lot of the leases we deal with, when they go month to month, the properties are always very generous and still give them that 30-day notice to vacate. I've seen it once or twice where they only give them 7 days, and it's legal. But 9 out of 10 times, I would say almost 95% of the time, the properties will still give tenants that 30-day notice. If someone is in a week-to-week lease agreement, like usually in boarding houses, the property owner only has to give them 2 days notice. That's it. It's a week-to-week lease. And these notices, by the way, always have to be in writing. So they could only have to give them a 2-day notice. Now, if a person is in a mobile home, they're living in a mobile home, the notice to vacate must be given at least 60 days before the end of the current rental period, regardless of the term of tenancy. Doesn't matter if it's month to month, week to week, yearly. The person in the mobile home who's renting that unit has to have at least a 60-day notice. Now, can anyone tell me why that is? Or why it may be that they get so much more time?
Because they may have
Is
to
it
move
because-
the mobile home? Oh, I'm sorry.
No, that's what I was going to say, because they may have to move it.
Yeah, they may have to move that entire, because they're renting, they may own the property, but they're renting the lot, okay? And they get a notice to vacate for that lot to be removed from the lot because they're not paying their lot rent or whatever, or they've had lots of violations and they want them out. You all know how hard it is to move a mobile home? And especially with the people that we work with, some mobile home units, some whatever they call mobile home parks, they won't take an older mobile unit because nowadays, if you have a really old one, it doesn't meet the requirements. So it's not even up to a new property owner. You might say, oh, I found this spot, and the property owner would accept you, but then they're like, your unit was, built in 1984 or what have you, and it does not meet the now newer state requirements to have a mobile unit on this property. It's tough. And that's when you all hear in the news and everything about, oh, they're kicking all these people out. They're shutting down the mobile home park. Well, a private developer has a right to sell their property. I just sold my house. People have a right to sell their property. And I know this is going to sound terrible, but they're under no legal obligation to help the people who live there find other housing. I will say I've been a part of that and I've seen it happen several times, and the landlords will usually give people 6 months notice. 6 months. They will also have people come in like from the county or wherever and try to help people find other housing. So I don't care what you hear on the news, I've been in the crux of it and I've seen them really try hard to help people find housing. But you all know you have some people who will sit in that unit, they will sit and they will not leave until the last hour, the final hour. And that's when you really hear it on the news. So let's say the landlord gives someone a 30-day notice, all right? Either the tenant's going to move out or they're going to pay it and everything's good. They're going to pay whatever they owe. If they owe money, or they're going to cure whatever the violation is, or maybe they wrote a reasonable accommodation letter and the landlord says, okay, you can stay. The property manager, it's been approved for you to stay. Good and well. If neither of those things happen, if nothing happens to cure that violation or that notice to vacate, then the landlord will file with the court a notice to evict. Now, how can they do this? I have seen, and I don't know if it's true, I do believe it's true, the property itself should not be the one serving the tenant with that notice, that eviction notice. It should not be the property. It has to be a sheriff or someone legally allowed to serve a summons. Like we have people you can pay, and that's what they do. They serve summons on someone. It can be a copy, could be given to the tenant in person. They just say you've been served. They can mail it to them. Usually that would be certified mail with a return receipt to prove that it's being sent to them. Someone leaving a copy with someone of suitable age. What do I mean by suitable age?
18 and older.
Yes, someone of legal age. In our society, 18 and over is a legal age. And someone, it should also say someone who understands, because we have some 18-year-olds who biologically might be 18, but they may have certain developmental delays or something like that. So you don't want to leave it with an 18-year-old who has IDD or something like that. It should be someone who can really understand what it is. On last resort, if there's no other alternative, the sheriff or whomever can post a copy in a conspicuous place where the tenant will see it. Usually they leave it on their door, which is really embarrassing, but hopefully they'll put it in an envelope or something like that so no one would know what it is. But that is a last resort and it is permitted in North Carolina. So if the landlord files his court eviction within 5 days of the court filing, the tenant must be served with the eviction. So if I'm a landlord and today is the 14th, by the 19th, that tenant has to receive that notice. I can't file it today and give it to them on the 20th. I cannot do that, okay? It has to be within 5 days. And the court date must be no more than 14 days after the summons is issued, okay? Again, we can't drag, the courts don't want to drag these things out. And I think people have a right to know, what their future is going to look like and what options they have. So if you have the court date, the tenant needs to be present if they want to fight this. They want to contest the eviction, they need to be there. They can have witnesses, they can have documentation, they can put people on the stand. They can do that, and I've seen people do that, okay? Again, extremely rare, extremely, but they can do that. If the tenant doesn't want to show up, if they're like, I'm going to leave anyway, but I'm gonna wait it out. I'm going to stay here as long as I can. I had one tenant say, they're going to have to put me out. I'm not going anywhere. Well, I said, well, they will put you out. The sheriffs will come and they will put you out. But that tenant refused to move. So if the tenant says, if they're willing to vacate the premises, they can even tell the landlord, I'm going to be gone by such and such date. The landlord can rescind that eviction. So it won't be, they don't have to worry about going to court. The court will cancel the date for the eviction to take place. So no worries.
No, you just need to get it notarized. This I did.
I hear someone talking. Is there someone? I'm sorry. Okay. I thought they had something to help me with. It's okay if you do. Please speak up if you want to chime in and help me out. I'm always willing to accept that. Also, if the landlord only wants possession and the tenant knows that, no matter what they do, they've tried to pay this and that, they'll say, why should I bother going? The outcomes, I already know what the outcome's going to be. So why should I bother going? Why waste their time if the landlord has already told them nothing's going to work, It doesn't mean they still can't appeal if they wanted to try to appeal. But I think if they really wanted to appeal, they would have been there at the court. So, but they don't have to be there if they don't want to. So what happens if a person loses with the court eviction? Then the landlord has to go back and file what we call a judgment for possession, okay? The tenant has 10 days to file an appeal with the eviction. If no appeal is filed, the landlord files the writ of possession. That writ of possession is filed with the court, and with the sheriff are the one who have to be the one to follow through with that process. They will padlock the unit, okay? Now, sometimes that could be 7 days. Well, it shouldn't be any more than 7 days. I will tell you, I've seen it take more than 7 days. And that's because there might be something going on where the sheriff's office is really overburdened with something that's going on. Say, for instance, when the protests took place and things like that, all law enforcement was super, super busy. So it was understandable that it could take longer than 7 days, but typically it's 7 days that they have to make sure they padlock that unit. And then once it's padlocked, the tenant has 10 days to remove his or her property from the unit. Now, this is where it gets kind of sticky sometimes. That tenant has 10 days, not 10 business days, but 10 days to contact the landlord and make arrangements to remove their property. That does not mean that they call them and say, I'm going to come get my stuff. The landlord makes arrangements to meet them there. And they're like, oh, well, my brother couldn't bring the truck, so we have to come back. Sorry, the landlord does not have to work on your schedule. Whenever a tenant comes to get his stuff, his or her stuff, within that 10-day time frame, you better be prepared to get all your stuff. The landlord does not have to keep coming back because the tenant is not prepared. So how does the eviction affect a person's credit report? Well, fortunately, it no longer does. It used to be as soon as an eviction was filed, it went on a person's credit report. As soon as it was filed, that's how it would happen. But as of 2017, the credit bureaus, reporting bureaus, they no longer put civil judgments or tax liens on the credit report. It really didn't do anything but make a person look bad. And that's something that's usually settled outside. A lot of times it can be settled outside of the judgment. Now, here's what happens. You won't have an eviction on your credit report, but what you will have is something from a debt collector maybe that says you owe money to Autumn Trace Apartments. A person, it won't take much to figure out, oh, they must have had an eviction or they didn't owe money. It can be an assumption, but it can easily be verified by calling Autumn Trace if that person applied to another place to live. So it's not an eviction, but you still could have something on your report, on your credit report. So I always encourage people to work out something with the landlord, with the property manager. Okay, so let's do one. Let's say this is Venus, okay? Venus has been living in her current unit for 15 months. So she's been paying her rent. A lot of time it's late, so she'll pay the late fees, and the property seemed to be okay with that. But recently, she hadn't paid her rent for 2 months. So she got a 30-day notice to vacate 5 weeks ago. So she got it with a 30-day, it's been a week past. So the property even gave her an additional week. She hasn't moved out. And now she's got to go to court because they filed a court eviction. So let's see what's going to happen with Venus. All right. Who's got a calculator? Who's going to be my volunteer for a calculator? My accountant. I need an accountant. Anyone? I see all y'all volunteering. I got a lot of folks here. All these people here, one of y'all could be an accountant.
I could do it, Miss Natalie, Miss Monica.
All right, Monica, you're my accountant. Okay. So the courts filed the eviction, the landlord filed an eviction on 9/3. Okay. So September 3rd. Within 5 days, Venus got served that eviction notice. Okay. It was within the time frame, like we were told. Like I think we said 7 days, so it was within that time frame, or 5 days. She got it. All right. How many? So are you counting these days up, Monica? I want you to count all these days.
Mhm.
Now, okay, Venus wouldn't have got that eviction notice if she hadn't ignored the 30-day notice to vacate. Talk to the landlord. Say, look, I don't have the money. But if you want, I understand I gotta leave. Can I have an extra week? Or can I make payment arrangements? Something, or both. So we're at 5 days now. On 9/22, so Monica, from 9/8 to 9/22, there's a court hearing. Venus goes to court on 9/22 and she loses, okay? Or she doesn't show up to court, so she's going to lose by default anyway, okay? So that's what happened with Venus. Venus doesn't appeal. She's got 10 days. Monica, got to add these 10 days because they had to wait 10 days before they file anything else. So Venus doesn't appeal. And guess what? Venus must be one of those people who says, I ain't going nowhere. And she doesn't move out. Well, the landlord had to wait. They filed a writ of possession. Okay? 10 days later, they filed that writ of possession because she had 10 days in order to see if she wanted to, if she wanted to move out, and they can file that writ. So they filed the writ, so that if Monica add 10 more days, now the sheriff has 7 days. 7 days to padlock that unit, and they do it within that 7-day time frame on the 7th day, but they do it. Like I said, it could take a little longer, but usually it's 7 days. So, and that, Monica, you added that other 7 days, right? Okay, thank you. Now it's padlocked. Venus has 10 days to contact that landlord, make arrangements to get her stuff out. If Venus doesn't get her stuff out, if she doesn't contact the landlord, or she doesn't get it out on the first time that landlord meets her, that landlord could sell it, give it away, trash it, do whatever he wants to do with it. So from the time it was padlocked and there was 10 more days, Monica, how many days is that altogether?
56 days.
56 days. Do y'all see how long it could take for someone to get out of a unit?
Mhm.
Now, that's why I say it's important to understand when someone gets very frantic and says, I have to be gone in 5 days. No, they don't. I know this it is somewhat of a lengthy process, but it gives the tenant time to make other arrangements, time to work out something with the property manager, time to find somewhere else to live. The problem that I see a lot, and you all can chime in, during this eviction process, if you've worked with someone, where have you seen them get stuck in this whole process? Where have you seen them get stuck? Anybody? Anyone work with someone during an eviction? Anyone ever went to court? An
I
eviction?
think after filing the appeal, that they have the right to file an appeal.
Mhm.
People get stuck, even if they're late for court and
Mhm.
there's a judgment against them, they can still file that appeal so that they can be heard. So for me and the clients that I work with, I think that appeal process, they don't think they have a right once a judgment is against them to still
Right.
file an appeal to give time.
Yes, and it's written out, but they don't realize it, that they can file that appeal, Monica. You're right. So that's why it's so important for us as providers and as people who work with those who are living in units, and we're working with them on sustainability when it comes to tenancy. It's important for us to understand what their rights are. Is there something in the chat? I thought I saw something in the chat. Larissa, is there anything in there?
Yes, it says, so are there private landlords who don't follow the legal guidelines and padlock early or move the tenant's possession out early? Oh, yes.
Or yeah, they'll lock it, they'll change the locks. They can't do that, and they will get in big trouble to do that. But that's a good question. Yes, that does happen.
And
Unfortunately.
oftentimes our private landlords don't really, I mean, they may have 1 or 2 properties and they may not really follow the laws. We have, so that's where I think it's important for you all to advocate on behalf and inform the property managers.
Yeah, and they're we're gonna next month we're going to be doing a training on we're gonna actually pick apart a lease. And what Larissa said is so important because we have landlords who don't even know how to write out a lease. And honestly, I have to say, I don't think that they're being intentional They honestly do not know. So they'll put rules in there. Like, for instance, I saw one where it said that anything, any damages or any repairs, it said, not damages, any repairs under $300 will be the responsibility of the tenant. Anything over $300, then the landlord will pay. Can that happen, y'all?
No.
Absolutely not. But again, I don't think the landlords always know. They feel like they're protecting themselves financially, they're protecting their property. So I don't know what date it will be, but it will be sometime in May that we'll be breaking apart a lease, and we'll let you know, check the provider network. Larissa, how else is it advertised? Is it on the provider network page of our website?
Yeah, we do it through Constant Contacts. We send it through the provider network. We throw it through all of our communications platforms. But I will say that I did have a lease that's charged, stated that they were going to charge $10 a day for every day they're late.
Oh yeah, I saw. Yes, I saw one like that before too. Yep.
Can they legally do that?
No, they cannot. No,
Nope,
there
we absolutely cannot.
you can only charge. I want to say it's 5% of the lease, or 25 for late fees,
$15, I
or
think.
20 or $15, whichever is less. And
$15.
another thing, I had one. This is just giving you all some examples of why it's important for you to understand all the processes around tenancy. Somebody was living in a boarding house. This is when I was working in still at Alliance, but ILI, Independent Living Initiative. A landlord wanted, it was a boarding house. They said the rent was due weekly, but somehow in the lease, the agreement, it was written that they had to pay monthly. I said, no, they don't. If it's not a monthly agreement, if it's a week to week lease, tenancy lease agreement, then they don't have to pay it monthly. And then they also were trying to get a security deposit for a whole year. They cannot do that. There are specific laws in North Carolina how much they can charge for security deposits, for late notice, for late fees, return check fees, all of that. So anything else? I thought I saw something in the chat before I go to the next slide. No.
It says, what happens if the landlord, it does say, somebody asks, what happens if the landlord changes the lock? What's the tenant's rights, and where could they go to get help?
Legal aid immediately.
They can go
quick, fast, and in a hurry.
And they can also go to the Human Relations Commission. So you can go to both of those.
Yeah, and I don't know, I think I have that one on the slide. I may or may not, Larissa. If not, I'll add it.
Yeah, and that's in every county. So, and they may refer you on, but.
What's important also to realize is that please, please, please let them know they still have to pay their rent. I know I mentioned it before, but even in the case of, a lot of times people will get evicted, and when they get evicted, I'm sure some of you have seen this, all of a sudden they start talking about all the things that are wrong with that unit. If there were things that were wrong with that unit, you can't stop paying your rent. Only with a court order giving you permission can you stop paying the rent as long as you're still living there. So lots and lots of stuff around tenancy. That's why we're doing these trainings, and that's why we're grateful to the questions you guys ask and things like that. So I already mentioned how a new property or prospective property can find out about your past eviction, even though it's not on your credit report. They can still find out because, again, it doesn't take a rocket scientist to see that you owe Autumn Trace $1,200, okay? And that's how they find out. So how do we deal with the evictions? Again, don't ignore it. Try to work things out with the property manager. I say pay or leave, and a lot of people say, well, I don't have anywhere to go. Eventually, it might take a while, as we saw when Monica added up all those days. It's going to take a while, but they will get you out of there. They really will. So sometimes the property managers will even put your things on the street. If you don't come and get it, they won't throw it away. They'll put it on the street, still giving you an opportunity to get your things. Okay. But just don't ignore it. Put payment arrangements in writing. It's just like with any other credit issue. I will never make a credit agreement or a payment agreement with anyone if it's not in writing, because you all know if it's not in writing, it didn't happen. Okay. You need to always have a backup. Okay. If you can't keep up with those the payment arrangements, contact the property, let them know, ask for a deferment or an extension of some sort. The worst thing anyone can do is just ignore it, because it's never going to go away. I used to tell people when I worked, when I was a consumer credit counselor, one thing I used to tell people about student loans, and it's almost true about evictions, they will survive your death. A student loan, I don't care, you could be dead and they're still going to try to collect their money. Okay. And kind of like with an eviction, I mean, as long as there's a way to get that money, they're going to try to get their money. And just remember that a notice to vacate is not an eviction, okay? And you might have time to help that tenant save their tenancy. You just might. Was it last week, was it? We did the reasonable accommodations, there's payment arrangements, there's all kinds of things. Now, if a person received a notice to vacate, they're living in, let's say, a targeted unit, which we have another training on that, but it's a subsidized unit paid for with state funds. A person can have, if they owe money and they've got a notice to vacate and they're like, look, I want to stay. Can I make payment arrangements? They can make payment arrangements. And the good thing about it, if they're in a targeted unit, is they can add the money, extra money that they owe, the back portion or the arrears can be added to the current rent. So if a person is paying $400 a month, they can pay $425 until they get caught up. The good thing about it is it can't be more than $50. So I had one property, and I guess it was a new property manager because it wasn't a targeted unit. They wanted to add $125 extra per month to the normal rent. Well, it's a subsidized unit. The person isn't going to have an extra $125 a month. Again, that's why it's important that we try to gain as much knowledge, education, and information as possible about tenancies, about subsidies and things like that. Now, I even had a few people who I work with who they didn't even know that. And I had learned it only through all the dealings I have with the state. So it can't be more than $50, which I think is a pretty fair amount. And it's reasonable to help people get caught up with their rent. And that can apply. You might even suggest something like that if it's a private unit. Say, look, they want to stay. Can you add another $50 per month to their rent until they get caught up? Especially if a person has been pretty successful there for a while. We want to really help that person stay housed. We want everyone to stay housed. But if a person's really been successful, we want them to remain successful. So as you all know, COVID-19 has had, I think this is either the third or fourth extension now. People cannot be evicted simply because they don't have the money to pay their rent and they've lost income because of COVID-19. And this is for people who were employed. Now, we've had a lot of people who are on a fixed income, SSI, and they said, well, COVID-19 says you can't evict me. Well, they can, because you have not lost any income. You have not experienced a loss of income because of COVID-19, because your check is always the same. But again, this comes with us helping people understand not only the tenancy, but the laws as they apply to them. But we've had a lot of people not pay their rent because they thought they couldn't get evicted. And as a result, now they're playing catch up. So like I said, so I did have the North Carolina Human Relations Commission on there. Legal aid of Wake, Durham. I put these counties because these are the ones that we work with. But like Larissa said, if you call the North Carolina Human Relations Commission, they can also direct you anywhere you need to go as far as assistance. And does anyone have any questions? We've got some time for questions. If anyone has any questions or situations that they may want us to kind of brainstorm on to help out with.
This is Chanel. Would you be sending us any copies of this PowerPoint?
Yes,
Teresa?
it'll come out. It'll come with your certificates.
Okay. Thank you.
You're welcome.
Hi, this is Steve with Money Follows a Person. I work for the state and saw this and joined in. It's been very helpful because we do place a lot of individuals who are coming out of nursing homes into subsidized housing. So it's been helpful. So I appreciate all the information and asking those kind of questions about very savvy landlords and understanding what tenant rights are available for folks, and not to be hoodwinked by the landlord who wants the units rented, but tenants don't know what kind of things they could say no to or refuse there. So thank you for that. Just a quick question on the numbers that are here. I see legal aid of Wake County, but it's got an 828 area code. That's an Asheville area code. Is that a correct number?
Ooh, maybe not. Let me check that. I probably got the wrong number. Thanks, Steve. I'm gonna have to correct that. I'll have to check on that. I don't know what I was thinking. I'll have to check. Thank you.
Thanks.
Natalie, did you answer the question about if the client is fleeing from domestic violence situation?
No, I did not answer that question.
Yeah, so somebody asked about that. What if the person's fleeing domestic violence and their name's on the lease? You might want to
okay.
talk about that.
Yeah, so we're looking at the Violence Against Women's Act, where a woman who is on the lease and is fleeing domestic violence, they have, a few options. Either they can stay, but they want the locks changed or what have you. That can be done under the Violence Against Women's Act. They have to pay for that change for the locks to be changed, and give a key to the property manager, of course. But that property manager cannot evict them because they were involved in what the property would look at as criminal activity. As long as the perpetrator is not there and that person is involved, it even helps even more if they're involved with a domestic violence center. Certain parts of the Violence Against Women Act requires them to be involved with a domestic violence center. They want to know that these women or the victims, even if it's a man, that they're doing whatever they can to protect themselves and their family. So filing orders of protection, anything to strengthen your case. Now, on the flip side, if I'm going to say a woman, because that's usually the case. If a woman is a victim of domestic violence and she wants to leave, she doesn't want to stay there, she wants to go find somewhere safe, she cannot be, what's the word I'm looking for? She can
Penalized.
Penalized, thank you. She cannot be penalized for getting out of her lease, for leaving. So they cannot charge her for the remainder of the rent until they rent out that unit again. They cannot file an eviction against her for anything if she left due to domestic violence.
And then also, and it's not only a domestic violence center, it can be anybody who's helping a clinic. Or so if you have a member who you're helping because of the DV, that will also count at engaging in services for DV.
Also, the tenant with the DV situation, if she provides the landlord or property manager a safety plan along with that protective order, she's protected under the VAWA Act and not any penalized on anything as well.
Yes, and the landlord, thank you, Monica, for that, because they have to have a plan in place. And that's not just to protect her, but other people on the property as well, because we know that sometimes perpetrators can get very violent. So we want to protect everyone, not just the primary victim, but everyone, her children and neighbors and people around.
I have a question. Well, with these laws, do they also protect males? It's not just for women, but the males too, if they happen to be a victim.
Yeah, that's why I was interchanging women with victim, whoever the victim is, whether it's a male or a female. Yes.
And the reason it's gender specific in the law was just because a lot of women, it was primarily women that they were seeing, but it certainly protects all individuals.
Yes. Any other questions? Great. Thank you, everyone. Like Larissa said, you'll be getting a copy of this along with your certificate. I'm going to check the number though and fix it on the slide for legal aid. Thanks for that, Steve. And before we send it out, because I'm going to do that as soon as we hang up. Okay.
And I had one other quick question. Do you know if you guys are gonna have the accommodation letter writing thing again? Because I missed it. I wasn't able to join in when you guys had that. It matters how it's written.
Oh, how to do the reasonable accommodation letters?
Yes.
I don't know when we'll do it again, but Larissa can tell you how to access that information. Larissa, are you there?
Yeah, I am. I was on a call.
Oh, sorry. So
we will upload it to our website, so the training will be available on our website, and those who attended will also get the certificate with the video but it should be on our website in the next week or so.
thank you. Okay, any other questions? Is there another question? I don't know. I can't see everything in the chat. Okay, great. All right. Well, thanks everyone for showing up, and look out for we have another 2 more, I think, this month, and look out for the trainings for May. We'll be posting that probably in the next 2 weeks or so, or well, before that. So look out for that. And again, I said yesterday that we were in a meeting, the CST Collaborative. If you have any suggestions on topics that you'd like us to train on, please let us know, because the more we help you, the more you all can help the people you serve. So thank you so much.
Thank you, Natalie. Appreciate
You're welcome.
your time. All right.
All right. Bye, everybody.